Hi, this is Sue Rhodes with Adventures into Sovereignty again, and I'm here with Rod Class again. We're going to do Q&A number 3. So Rod has had a eventful week. He had a talk show call last night, and within 2 hours, I think there were, 80 people on that call.
Yep.
Lots of people watching this, what you're doing. This is a case in the Western District of Missouri Federal Court, Kansas City. It is an IRS tax case.
Yes.
And you were there to help the defendant, correct?
Correct.
Okay. He called you in to give him a hand with this case because he was lost.
Right.
Okay. So tell us what happened when you went in there. How did you wind up in this case? How did you wind up in court to begin with?
First off, we've been helping this gentleman for several months on his case. We've been doing documents. We've been trying to coax him, train him, teach with him. I ended up getting a subpoena from federal court, which means I had to be there. And what we were in pretrial, now ladies and gentlemen, you need to understand pretrial. Pretrial is where the judge gets the information and decides whether it is going to be damaging to the prosecution, whether they're going to allow the evidence or not. So you got to understand, just because you have pretrial, don't mean it's going to go in your favor. What they're doing is finding out what you have so they can put a lien on it or gag order on it, so you don't give it to the jury. Well, this was the case with me. I got called in. Mr. Stanley sat down and asked me about the Federal Reserve note. What's my knowledge? What's my understanding? Well, we got into the McFadden speech, 1932, where McFadden sat here and said that Federal Reserve note is not money. And at that point, I pulled out a $1 bill. I showed it to the judge. And I says, what does it say across the top here? I says, what's it say? She wouldn't say anything. So I said, it says Federal Reserve note. That's what it says across here. And it says this is not money. This is a mere promise to pay you someday. And we got into Title 31, which is the financial and money system of the United States. But we got into the statutes at large. And we proceeded to explain that whenever the Treasury went to the Federal Reserve, they never got money, they got credit. And they ran credit all the way down. Now remember, I have an IRS agent and a Treasury agent sitting on the side of the prosecution. So now I am laying out their finance setup. It's all credit. We got into Title 12, and we showed that it was credit obligation in the United States that only Federal Reserve agents can handle Federal Reserve notes. The very note that I was showing the judge. That's only good for Federal Reserve agents and the banking system. It was never designed for us. We got in and show where the signature was the collateral. We got into Title 18, Section 8, which says obligation of the United States. So we pretty much laid out that there was no way for people to pay taxes. And this is what Mr. Stanley asked me to explain, to lay out. From congressional records all the way down to the statutes at large, down to the United States codes. Well, then he asked me about the PAG. Well, I had my credentials. And the judge asked me, he says, where do you get your authority? I said, I got my authority from Congress, the same place you got yours. I said, the difference between you and I is this. When Congress created the Judiciary Act, I touched the bench. I said, they created the building. They never filled it. When they did the U.S. Marshal Service, again, I touched part of the building. They created the building. They didn't fill the office. Same thing with the United States Attorney's Office. Same thing with the DOJ. I said, but on the other hand, in the 1866 Vindication Act, under Title 42, 1988, Congress gave us the people the authority to bring accountability charges against the system. Well, I showed him my credentials, and the prosecutor come up, looked at my credentials, and just sort of snickered. I says, here's my congressional authority. Where's yours? He just sort of dropped his head and walked off. He could not answer me.
Of course not. He couldn't answer you. He doesn't have any.
Exactly
In
right.
fact, his congressional authority is that he has no authority. Not on this land.
So anyhow, he says, and Harold said, what is actually your job function? I says, as a private attorney general and a bounty hunter, I says, my first obligation is if I witness a crime in a public office, right here in this courtroom, if I witness a crime, my first duty before I can do anything, I pointed over at the attorney sitting at the bench for the United States Attorney's Office. I pointed over at Becker. I says, I have to contact him first. I have to let him know that a crime is being committed in this courtroom.
Okay, let's go back now. What crime was committed in that courtroom? Let's lay that out.
Okay, at this point in time, there was no crime being committed at this point in time.
But you knew there was going to be one.
There's going to be one.
Yes.
I already had a document written up for a judicial notice of impeachment against the judge and against the prosecutor for ethics violation, rule violation, disregard of federal statutes, disregard of the Constitution, disregard of the rules of court, disregard of the Supreme Court decision, disregard of the fact that there was no money at all sitting here and it's all fraud. I already had all this wrote up. So my job was, as I said on this paper, I explained, my job is that once a crime has been committed, before I can act, I have to notify the Attorney General's office or the United States Attorney's office, which is this man right here. I have to serve him with notice that a crime is being committed before I can act. If he takes care of the problem, then I don't have to do anything because he's fixing the problem. But if he doesn't fix the problem, I now name him in as an accessory to the problem. Now I charge them with an SF-95 under a federal tort claim under Title 28, Chapter 171, which sits here and says, is that the United States and all of its employees and all of its agencies are absolutely immune from any prosecution. They can never be charged. I said, but then it's got two little words. It says, unless. Unless. Unless what? Unless you notify the agency that's committed to crime, notify them first and give them opportunity to fix it. So this was the secret of this. We can't do anything unless we go back and give them first opportunity to cure.
That makes sense.
Yes. So what happened here is they cut my time short. So she said, okay, that's enough. So they put me back out in the hallway. Mr. Stanley's wife come out and sat here and said, Rod, they just stricken your testimony off the record. And they're going to bar you from coming back in. Great.
Now we're talking a crime.
I went, yes. What do you mean, yes? I said, they just committed a crime. They just suppressed evidence that showed that Stanley was not guilty. He could not have been charged for tax fraud when there was no way to pay for it. And I told them precisely where the information was at, and the judge suppressed it and stricken it from the record. Now they violated the rules. Mr. Stanley was also told he was not allowed to bring in the law or the rules into that courtroom anymore. So again, yes, a crime's been committed. So immediately I went down to clerk of court. I already had our signatures on the paperwork. I had Carl Weston's and mine. We both signed off as PAGs. Now we left Mr. Stanley's signature off of this. Because see, as a PAG, I filed for an entry of an appearance as a third party into this case. I filed as a third party. Not to counsel, but as a third party intervener with knowledge of crime being committed. And I came in under the 14th Amendment, Section 4 bounty, that I was report a crime under a public debt fraud. That was my entry of appearance. So when we went down to the court, there was John and Richard and I. They went with me because they wanted to see what I was going to do. So there's three of us went down to the courts. I went down to the clerk of the court and says, here, I want this filed into this case. And they went and he said, well, Mr. Stanley's name's not on it. I said, that's right. His name isn't on it. Well, I filed an entry of appearance. And at that time, I pulled off my suit jacket and I had my bounty hunter vest on. That I walked in here with. I am now in my official capacity under Congress to serve. I told them I'm in here officially now to serve. I want it stamped. I want the judge to get a copy. And I'm going to take a copy up to the prosecutor. So they stamped it. They filed it. I went up to the courtroom. I waited for the jury. Now, ladies and gentlemen, now you got protocol here.
That's what I'm going to try and slow you down on so that we can get everybody caught up as to the protocol. Yeah. Because now you were actually, you found out your testimony had been stricken. What was the reason for that? Did they give a reason or did they just arbitrarily say, we're going to strike it?
We're going to strike it because you can't use the laws.
Oh, you can't use the laws as evidence.
Can't use the laws as evidence.
In some courtrooms, okay.
With the law, you can't use the laws as evidence as a defense.
Okay, gotcha. That sounds like a cartoon.
Yes, it is.
It really sounds like you're watching a cartoon here. Okay, so then your response was to go down and file what?
Well, the judicial notice of judicial impeachment.
Okay, now did you file it with judicial notice so that it goes straight to the judge?
Yes.
Okay, gotcha.
It went straight to the judge, and also I had to serve the prosecutor because there was a crime being committed. My first obligation was to get it filed, get it into the judge's box, and then I was to serve the prosecutor. But I had to wait because this was jury selection. I could not walk in there with the jury selection going on. I had to wait for a recess. The jury had to be out of there. This way there was no contempt of court, no interfering, no disruption of the court.
Mm-hmm.
Okay, so I waited for the jury to leave, and I waited for the judge to get off the bench. She's off the bench, the court's in recess. So now there is no disturbance in the courtroom. So what I did is I walked in my vest up to the prosecutor, and he had the IRS agent and the Treasury agent there standing on the other side of the bar. That little railing that splits the audience from the courtroom.
He's on the inside of the bar towards where the judge's bench is?
Yeah, he's in there by his table, his bench.
In his sandbox.
Yeah,
right.
In their sandbox.
Right.
So I walked into there, stood on this side of their sandbox. I walked up to him, and he looked at me and says, what do you want? I says, I am here in my official capacity as a PAG and bounty hunter. I'm now here to serve you and give you notice of a crime that was just committed in this courtroom. I went to serve him, and his hands went up in the air. And they always do. The attorneys, cops never take paperwork from us. They figure if they don't take it, then they've never been legally served. If we try that, we get arrested. But when he did it, I looked at him, I said, it doesn't matter whether you put your hands up, you are officially being noticed and served of a crime being committed in this courtroom. I dropped the paperwork at his feet inside the bar area. The paperwork hit his feet, so he's already been touched with the paperwork. I turned around and walked back out. Well, I went out and put my suit jacket back on. About that time, some lady come out and says, Mr. Class, judge wants to see you. I said, okay. So I went back into the courtroom. Now, I stayed on the civilian side of that bar. I didn't cross the bar. And she said, you made a disturbance in here. I said, no, Judge, I most certainly did not. There was no jury members in here. I made sure of that. I made sure you was off the bench. There was nobody in here except for Mr. Becker, the IRS agent, the Treasury agent, Mr. Stanley, and Carl Weston. It was the only people in here. And I went to serve the prosecutor. Well, she asked the prosecutor what was going on. Well, he said, well, Mr. Class, there was no witnesses in here, no jury members. The court was out of session. He did drop the paperwork within the bar, not outside the bar. And she looked at me and she says, who do you think you are? I says, I told you on the witness stand what my job was. I told you if I witnessed any crime, any corruption, my job was to contact this man and notify him of a crime. He just got served a notice of a crime being committed. I did my job. Now it's up to him to either do his and stop it, or I will file an SF-95, I will file a tort claim against you, and I will bring an administrative claim. She looked at me, her mouth dropped. Well, you just go file your SF-95. I says, I am, and I will. Well, then you get all out of my courtroom and you get off the 8th floor, and I will have the marshals make sure you don't ever come back up here again. I said, I don't care. It's not my problem. My job was to report a crime. I did. If he continues, he's now aiding and abetting. He is now an accessory.
Well, not only that, but let me stop you here, because he put his hands up, almost knowing that he was going to get something from you, not really knowing what, but knowing he was going to get something, but he wasn't willing to take it from you. So he already had some sense of needing to defend his little club there, right? The prosecutor. So this is evidence right here of the closed union shop that we're dealing with here, that you were dealing with when you went into this situation.
Well, exactly. They don't want to be informed of a crime being committed in their own courtroom, in their own presence, what they're getting away with.
Well, yeah. Well, you put him on notice.
Yes. Yeah. And I put him on notice on the witness stand when I was asked what my job was. And ladies and gentlemen, this is the significance of knowing the rules, knowing their language, knowing their job, and knowing congressional intent. Because technically, by me doing what I did, had not had the knowledge, I could have been found in contempt. My butt could have been thrown in jail. But because I had credentials, and I was able to back up my credentials, and I was able to back up what I said, they couldn't touch me. Why? Because I was well within the legal rights of reporting a crime and addressing them and charging them. That's what we got to understand, ladies and gentlemen, is that this is a charging position. You're not a defending, you are charging. You're making claims of violations. So what happened is when I went down to the cafeteria, U.S. Marshals showed up. Whenever they came down, they came over to me. And they sit down and says, we heard that you created a disturbance in the courtroom. I said, no, sir, most certainly did not. I said, the jury was out. In fact, the jury's down here. Judge was off the bench. I said, I served notice on the prosecutor of a crime being committed. And of course, the U.S. Marshals asked me, where do you get your authority to do this? And I turned around and I explained it to them, where my authority comes from. And they asked me, says, how much authority really do you have? I says, let me put it to you this way. If I had the backing you guys have, I'm the only one who can arrest you guys. I'm the only one who can bring charges against you and arrest you. And same thing with the judge. I could pull a judge off the bench if I had the backing. You guys can't. I can. So with what I explained to them, we didn't realize you had this much. I said, yes, understand the history of this. But then we got into the case itself of the Federal Reserve. And I went through the whole process of explaining the McFadden speech in Title 18. Well, when we got done talking, the bottom line came down to is you didn't commit a crime at all. You didn't create any disturbance. You was actually doing your job. I said, that's exactly right. But they sit down and said, well, the next time you decide to serve them, they said, we technically are the legal servers for this court. I said, you may be, but not when I walk in and I have documentation and I witness a crime. My authority overrides yours. I am to serve these people, not you. I'm the witness. I'm the bounty hunter. I'm the PAG on this. I'm the prosecutor. They said, well, we understand where you're coming from on this, but we've never come across anybody like you. We never had anybody ever explain it. So we come across a lot of people out here but nobody's able to explain it in a fashion that you laid it out. You showed us where all the stuff was at. Most people talk in generality. She says, you did not. You specifically stated where this stuff was at. So because you specifically stated it, we find nothing wrong with what you did and how you did it. You actually have the authority. It's just a do. And that was the end of it. They left me alone.
Okay, so of course they're going to leave you alone. There's nothing they can do with you at this point. You've made it clear. You've pointed at the materials for them to look at, and now it's up to them to go and check out your information. Now, I guess what I want to do is stress the fact that people will say, Rod, you're playing in their system. You're just playing in their system, and we don't want to have anything to do with their system. But you're not playing in their system. You're actually, if there were enough of you out there knowledgeable in this, you would actually be taking the system down piece by piece by piece. Couldn't you?
Yeah, because this goes back in with what we did in my DC case. We had 50 people that filed entry of appearance. They filed the SF-95s. 50 people got notices from the different administrations telling them to go sue the judges and sue the prosecution. They were told to go sue them. They was told to go bring a tort claim. They stripped their immunity. Had these 50 people had the knowledge that I'm sitting on, and we tried to teach them, we would have had 50 lawsuits against this judge, these judges in D.C. and the prosecution. And I'm telling you right now, this Missouri case never would have happened. Because we went back in. See, where the problem is, what people don't understand is that the system cannot play on the tort claim side. They can't walk into the administrative courts in the fashion that we can. That administrative court is for us to walk into to bring a claim of damages and injury. Because when we go in and file a tort, now I filed into 19 administrations on this federal judge. We got 3 defendants in this thing. We got 19 administrators. These administrators will come back and they will tell me that they've done their investigation, they find nothing wrong, but if I don't agree that I could go file a federal tort claim and I could sue them in their individual capacity. Ladies and gentlemen, playing in their arena is taking their system down, because it's like I sit down and show the U.S. Marshals, and they was absolutely flabbergasted. I showed them the 1925 statutes at large, showed where the United States codes were never passed. I showed them the 1935 Federal Registry, and the National Industrial Recovery Act says these are strictly administrative regulations. I said, now, you read it, you've seen it. Tell me how it applies to me. He says, it don't. I said, that's the point. It don't. I said, who's it applied to? It says it applies to us. I said, you're right again. I said, so this is how I'm taking you down. I'm using your own statutes that Congress says it is your regulations, how you're supposed to operate. And when you step outside of that procedure, it's my job to bring you back in and do accountability on you. These guys understood that. They said, this makes sense. I said, yes, it does. So we're playing in their field, but it's their rules for their punishment if we know how to go back and use it. This is part of the training. This is part of the education.
Well, the field that they're playing in is one that they've made up. It's an illusion. They've gotten by with so much crap over the years that they're making up their own stuff because they know they're going to get by with it, because nobody comes along and questions it, because all of these laws, all this research you have done, much of it has been kind of hidden. It's been like a trail. You go from one thing to another, and that's how you find it. It's not so like you can go out there and know what you're looking for. You had to find out the hard way.
Yes.
You've done all that hard work. So now that you have done all that, we know now where to look, thanks to people like you. We know where to look.
Well, see, this is the difference between the judicial and the administrative. When you're operating within the judicial system, you can't use this stuff. It's like the judge says, you can't use the laws in this courtroom. You can't bring the laws in. You can't bring the rules in. Well, yes, I can. But the point being of it is, the moment you go to the administrative, and this is what we're finding out. Under the judicial side, they're not operating under that public office. They're operating under a de facto. They're operating under a foreign corporation side. Okay, the moment you go to the administration, what you are doing is you're bringing them back into that public office that they were supposed to be in, and you're taking them out of that de facto side and you're bringing them back into the constitutional side of what they agreed to in that office. This is why all these administrative courts are coming back and saying they're not public officials. They don't hold that office. You people are not understanding when they're telling you they don't hold that office. Well, we just lost. No, you didn't lose. They told you they don't hold that office to be able to do to you what they're doing. This is a tort claim. This now, by understanding their rules and their regulations, now allows you administratively to go bring a charge for fraud against them and bring this into the federal court of claims for federal funding fraud, because that public office has obtained federal funding under the pretext that they actually work there. And the administration said, they don't work here. We don't recognize these people. They're not part of us.
So we've got people that are getting federal funding, they're getting a paycheck, but they don't really exist. Their positions don't really exist.
Exactly
right. And this is the bucket of water you're throwing in their face, because a lot of them don't know it.
And this is why learning this stuff is so significant, because actually what you're doing is you're coming back in and exposing. There is a case up in Ohio, a foreclosure case.
Oh, yes. Let's go into this. This is fascinating.
Okay. They went in and they took this couple's farm off of them. They took over 250 acres off of them, farmland and industrial complex and a commercial complex. They've been hammered for 7 years, hammered. Well, I came in and I did the SF-95. At SF-95, I brought charges against 4 county commissioners, judge, prosecutor, 4 lawyers, and a highway patrol barracks, a sheriff barracks.
Okay, what were the charges for?
Okay, one is for fraud, is because there's, again, this goes back into the bankruptcy. There's no way to pay. George W. Bush in 2008 did a bailout. And people aren't recognizing, understanding bailout. What's that mean, bailout? When he did the bailout, he paid everybody's loan off.
We paid everybody's loan off.
Yeah, we paid our own loan off the moment we signed that note.
Yeah.
But the point is, it was publicized that that bailout was to pay off everybody's mortgage. They failed to pay the mortgage off. They took the home. They took them out at gunpoint. They had 60 stormtroopers in there, all covered up with riot gear masks, so you couldn't tell who they are. They had M16s, and they pointed at these people, and they had another 20 additional outside. You know, how many armed people do you need inside of a house?
For 2 people.
Yeah, for 2 people. You don't need 60. But the point being of it is, we brought charges against them because of the bailout, and we brought charges because under the Federal Reserve Act, that house was paid for the moment they signed the note. So we're bringing fraud in. By going in and doing the SF-95, what has happened here, we went back and notified all the agencies. The Ohio County Council officers or officials, the OCCO, I get a letter back telling me that all these county people that we've made a claim against, he says, we don't have any jurisdiction over them. Well, wait a minute. If you are the Ohio County Council officials, And your job is the administrative side to control the county officials. If there is a claim of damages, a claim of injury, you are the court system for these people, and you're coming back and telling me you have no jurisdiction over them? What you're telling me is that these offices are vacant. These are not really county officials.
Yeah, and that is the information that you want. A lot of people would stop right there and go, oh, well, now who do I go to?
Exactly.
You know, instead of reading between the lines and realizing that what they're saying, and you want that information. You want that response from them because that is the truth.
Right. And we got a thing from the Ohio Bar Association that we brought in charges against the board members and the judge, and they're coming back in, and they said because there's a conflict of interest, we can't get involved against this judge and these parties because they send it down to another council. Well, wait a minute. If the Ohio Bar cannot get involved, then how can the Ohio Bar sit down and swear people in to operate and to work? So again, they threw their own people under the bus. And ladies and gentlemen, this is part of what we're trying to teach administratively. This is why this is so important. Because when you can go back in and you can nail them under what their job description is supposed to be, how they took that job. I talked to Carl. I asked Carl, I said, you ran for county commissioner several years ago, right? He says, yes, I did. I said, okay, what has happened here is this. You ran for county commissioner, and let's sit here and say that you would have won it. Your office would have been under the Constitution as a county commissioner, right? He says, yes. I said, but you and I both know once you took that office, you stepped out of that office over to the de facto side, vacating that office. He said, you're exactly right. That's what I would have done. I said, so by doing this administratively, this is why the county council is coming in saying, we don't have jurisdiction because these people don't work here. They know they're not representing that county office. They know they're representing a de facto. So what this means, ladies and gentlemen, is this. If we can start finding their insurance policies, start going to the insurance company saying, hey, okay, do you insure this county? Well, yes, we do. Do you insure this public office? Yes, we do. Okay, we just got documentation from the administrative side that these people don't work here. We now have an insurance fraud.
And you have it on a massive scale.
Yes.
One case, one foreclosure case that you walk into, how many different offices is what your complaint's going to affect? We're going all the way up now to the insurance policies of the Bar Association, of all of these, the SWAT team, of the Sheriff's Department, all of these people. That can tear them down. So one case with someone who knows what they're doing, with Rod coming in as a PAG bounty hunter, and now is infiltrating on his own an entire town with the truth.
Yes.
An entire town's offices, administrative, sheriff department, everything, and the courtroom. So you see how massive this is. People don't really understand, Rod, I don't think, how massive this is and what a spider web this is that goes right back into their system and screws them over, just like we've been doing with the truth, just like they've been doing to us.
Well, it is. But see, again, now, I just nailed North Carolina again through the Industrial Commission on a judge, prosecutor, state highway patrol. Again, the Attorney General is trying to come back in and say, well, they're not officers. They really don't work here. Oh, on the other hand, they have immunity because they're judges and they're public officials, so they got absolute immunity. But on this hand, they don't work here. So we got the Attorney General's office sit down saying over here they got immunity, and over here they don't work here. Well, if they don't work here, then they don't have immunity.
And who are we insuring? Yes. Yeah. And where is that pension fund going? Then to a vacant office?
Yes.
And who's collecting that? So where is that going? I mean, you see how far this can go. You can just keep asking the questions and getting these answers and filing SF-95s and tort claims against these people and going to their insurance companies.
And this is it, ladies and gentlemen. This is the reason in the training of this webinar of what we're trying to get up is that your avenues of remedy is out here. But the key to your remedy is being able to talk and stand your ground. Now, I don't care if you're using the, what's that called? What's that? A for Z?
Oh, A for V? Yeah.
Okay. The fact that you're pulling it out of UCC, the problem that I have watched with majority of you people is this. You're intimidated by that judge. That judge looks at you and you freeze up. I never had that problem. This is why when I got called back into the courtroom about me serving the prosecutor, the judge says, "Who do you think you are?" I told you what my job was. I told you if I seen corruption, my job was to report it. And I did. I didn't, well, Your Honor, I told you. Ladies and gentlemen, there's a difference between being belligerent and being factual. And I was factual with her. I stood my ground.
Well, you knew what you were talking about.
That's the whole thing.
Yeah. If you have that knowledge, you can have that confidence. And, you know, there's going to be several levels. Let's talk about now the different levels. We just talked about the different levels of corruption you're finding and the different levels you're going to remedy that.
Yeah.
Now let's talk about the different levels of training that are going to be required for something like this. Because there are some people that just want to know how to get out of a ticket. That's a different level of training there, you know, or they just want to deal with their city council. They got a note on their door because their dog's barking too much, you know, or complain about their dog barking and they don't even have a dog. Okay. So those types of things are at one level of training. And then you've got another level of training that would be more like going, you know, being able to register your own car, being able to not drive with the driver's license, and then actually being able to deal with some court cases where you're actually being summoned into court and you're going to actually have to go in. And then you have another level of what you're at now. And that's actually going into a court case and having them all scurry. From the judge to the prosecutor to the attorney buddies that he has to the city council and the county commission and the county bar association and the city bar association. You've got all of that going. So you've got like 3 levels here, I guess we're talking.
Yeah. And what you people don't understand is this. Once you understand the basis, I just want to learn this for me. Just for me, nothing else. What I teach you for you boils down to it can be used at any position, at any place, at any given time. That is the simplicity of this teaching. Once you learn the rules, learn their job, learn their language, of the congressional intent. Even if you're dealing with a parking ticket or a speeding ticket, the technique of being able to come in is that you address this administratively before you get into the judicial court. That's the whole purpose of this thing, is the moment you get tagged, you immediately go straight to the administrative court. You're going straight for the jugular on these people. All right, let's sit here and say that you're in. And this is where the Stanley's case is in Missouri. We threw a zinger into these people. And what we did, the moment the court was over on Thursday, we filed immediately a notice of stay, appeal judgment and notice of stay. Immediately. You're not supposed to do this until after you get sentenced. We did it immediately. Why? Because a crime's been committed. He now can go back to the appeal court and have this reviewed And if they find out that there was wrongdoing on that judge's part before he's even sentenced, they can have the case overturned. Well, going back to the appeal side of this thing. Now, we could also go back and notify the appeal that an administrative claim has been filed for judicial corruption and breach. Now, they're going to have to investigate this. So just because you're in a judicial setup doesn't mean that you have to stay there. You have options to start administrative claim immediately. You have options to start bringing charges and appeal into your case even before you are sentenced, which could overturn this whole thing. These are avenues, ladies and gentlemen, that even on the lower level of just me, my case, this can be done on your case. But what you don't understand, this same philosophy works all the way up through the ranks. It works all the way up through. So this could be, let's sit here and say that you do this here this year. Let's sit here and say 5 years from now, you got another issue that comes up with the government. What you learned 5 years ago, if you remembered it and you studied it, you could turn right around and use this whole same technique back again against them 5 years from now. Because if you know their rules, know their language, understand their job, because these are never going to change. Why? Because they've already been declared to be administrative law. They can't come back in and undo it because Congress found so many errors in these, they can never be law. So they would have to truly wipe this whole thing out totally, go back to the statutes at large, rewrite it under a new setting, and get it going through the Congress again. They're not going to waste their time. They're going to keep with these. So these will always be the same. These will never come down to us. It's their rules. It's their procedures. It's their guidelines. It's how they're supposed to operate. So whether it's today or 5 years from today, this knowledge is still going to be the same. It's going to be applicable. And not only applies in the United States, it applies in Canada. It applies in Russia. It applies in Germany. It applies in the Netherlands. It applies, you name it. The concept applies equally. This is the only thing that is understandable across the board that works if you know how to use it.
That's the thing. A lot of people just go, I don't know how he does what he does. I'm just going to watch what he does. And, but then you get yourself into a situation and you need some help. And what are you going to do? So this knowledge, even at the basic level, is very important because it's going to defend you whenever they come after you. And God knows there are so many groups out there, Rod, that are talking right now about, reviving the common law system, the organic government that's there, and, all of this stuff. Well, I don't know how you can do that without exposing this one. I don't know how you can do that without tearing down this one piece by piece. We built it. We allowed it to be built. Put it that way. We allowed it to be built. And we paid for it to be built. Now it's up to us to tear it down.
Yeah, tearing it down. If we go back in and do accountability, go back administratively, force them back in, notify the insurance companies. The insurance company will start dropping these people like hotcakes until they come into regulations. All right, this is like you have an insurance on your automobile. Okay, you go out and you get involved in an accident. Well, your policy didn't cover that. So therefore, you're stuck with it. And this is where these people are at. Their policy only covers that public office under the constitutional side of this thing. That insurance policy does not cover this de facto side. Now, they may have insurance for it. That is not part of this. They may have two different insurance policies. But when we go in administratively and we drag them into that constitutional position and we go after them, that's why the administration always comes back and tell me they're private contractors. They don't work for the state. They're not employees. And they're not. That job, that agency, that office is vacant. That's our key to this thing. That is our answer. That's why this stuff is so important. But it's up to you people what you want to learn. Is it really this hard? It seems this hard, but we're breaking it down through the very basis, and we're walking you through the straight rabbit holes instead of running you through all the rabbit holes.
Yeah, a lot of it is just knowing where to look,
Yeah.
observing what they do and reading their responses in a different way. Instead of saying, we don't have jurisdiction over this matter, and you taking that piece of paper and going, oh, well, I guess I can't do anything about this. Screw this government. Instead of doing that, you should be reading it as, this office is vacant and there's nothing I can do about it. And then going to that person that said that and say, well, where does your paycheck come from? So now you're getting both of them. You're getting one to admit that the office is vacant and he's not going to do anything. He'd rather throw this guy under the bus than admit that he has any responsibility. And now you can go after the guy who said it and ask him the same question.
Well, what you do is you first go out and get the one who you're after to start with, and you start bringing them in. We start hammering them enough, then they're going to be willing to turn over on the ones that turn them in and allow us to go back and hammer them. But the whole process of this, ladies and gentlemen, it's like I said on the witness stand. My first duty as a PhD and bounty hunter is to notify the DOJ or the United States Attorney's Office that a crime's been committed. That's my first obligation. Once I do that and they do nothing, then that obligation falls back on me. When they come back and says, look, we're not going to get involved, what they're saying is, you sue them. We can't.
Right.
Part of the reason is this. They can't sue them because they're part of the corruption. And they can try to take them in. The people that they're charging can point back, well, you're the one who gave me the federal funding. You're the one who knew I wasn't doing my job right. So by passing the buck to the people, and if you really go back and read the law, go back in under the 10th Amendment, the power falls back into our hands ultimately. The federal funding side of this says only the people can bring the charges, not the agency and not the employees. We are the only ones who go back and do accountability. This is what the administrative court was designed for. But this is why it has been so well hidden. Because they knew if we ever figured out and how to go do it, we could start taking them down and start doing accountability on them. And this is what an insurance man has sit down and told me. He says, you have finally figured out what it's going to take these people down. He says, you're exposing that these offices are vacant. You're exposing that the insurance is covering an office that is vacant, and that the people are in it are no longer really insured because they're operating outside of their insurance policy. It's like you being in construction work. All right, you have insurance to maybe do renovation, but you don't have insurance to build new. At the moment you try to build new, your insurance doesn't cover it. You now can be fined. You now can go to jail. Now you're under insurance fraud. So and this is the same thing with them. They are insured for that public office. They're not insured for the other activities outside of that public office. There's a contract here. So we go back and bust them on the contract.
So now I'm picturing, 200 PAGs across the country. What kind of damage you all could do? It floors me to think of it and how quickly you could do it, because word spreads fast among these people. They're going to see, one by one, them either going to jail or them being removed from office and exposed and having to live probably in shame for quite some time because, of all the trust people have had in them and all the disgust they're going to have for them. So, yeah, I could see how just a few hundred of you across the country could do major damage. Well, as far as exposing the system and letting the people in their community know the truth.
I am committing a lot of damage just on my own because what has happened up here in Ohio, the couple is now going out and all these public officials are not just walking across the street; they're walking across several blocks to get away from these. They were sitting here saying that the one county commissioner out of this one area does his grocery shop at 50 miles away from home.
Wow.
And they happened to be up there at that time. They come across his wife. They're talking to his wife. Everything was pleasant. He walked over, told his wife, let's go. We don't have time to talk. Let's get out of here. He was one that was being charged.
Uh-huh.
But these people, avoid going out. At first, they was being smug and arrogant. Now they're in a panic because they don't know what to do because I am administratively. See, this is where the judge in a judicial setup told the lawyers on this opposing side, because see, Carl and Vera in this foreclosure were the defendants. This SF-95 made them the plaintiff now.
Absolutely. Yes.
Here we are in a judicial setup. They were a defendant. I come in, did the SF-95, and it flipped them over to the plaintiff because a judge was called in to fix the problem. All right, now all these lawyers are now defendants in this case. They're facing lawsuits. They're going to be facing charges.
And they best have a lot of insurance.
Yes. And the insurance man is the one that we're talking to. We used to insure these people, and he's sitting back laughing his butt off because he said 15 years ago, the insurance company was talking about this very day. He says somebody is going to figure this out, and somebody's going to come in administratively and go after them. And when it does, they're going to blow all their insurance right out of the water. And that's what we're getting ready to go do with these people. But see, we're doing it in 2 states and a federal government. I'm going after three entities right now on this, plus my DC case. So there's 4 that I'm dealing with. Ladies and gentlemen, the PAG side is, if you start understanding it and be willing to start learning, we can pull this country back into the republic that it's supposed to be without going in and giving up your citizenship, trying to refine your status, doing all these things. All we have to do is go back in and pull these people back into their proper status of how they're supposed to operate, and we'll get our country back. And it can all be done through the PAG side of doing accountability and doing it administratively.
Very good. So here's our Q&A number 3. We're going to be doing some more. This is the latest in what Rod's been doing, and this is the damage that he has caused so far to the system. There's more to come, and we're looking forward to hearing that, and we're going to tell you about it. And hopefully you will understand or realize that, I used to think the same thing. I don't want to play in their system. I don't want to mess with these people. Well, in order to expose them, you have to mess with them. In order to fix the system that you're responsible for, because we pay for it, we sat back and allowed this to happen, not individually, but you know what I mean, over years. We were complacent. Anyway, it's up to us to fix it. So let's do that. Let's learn this and do that. I used to think the same thing. I don't want to mess with it anymore. I spent 15 years working for lawyers. I don't want to deal with these people anymore. But when you see the damage that you can do, not the damage, when you see the effectiveness of administrative process, let's put it a nicer way, and what the PAG and the prosecutor could do. I want to be a PAG now. I think I could do it. I really do. I mean, I can tell off people all day long. I can be that way if I have to, with the stuff that I know. I know how to be a mom. I know how to do that with my kids, whatever. I think if I know this well enough, I can do the same thing.
Okay, but there's something else here. We talked about this here a little bit last night too. It can be profitable.
Yes.
Because once you understand the PAG side, once you understand the prosecutor side of this thing, then you can be a bounty hunter on this. And once you go back in administratively, and see, this, ladies and gentlemen, this is the key. This is why. Once you go back in administratively, and under the 14th Amendment, Section 4, Once the system allows you to sue these people, you're no longer suing the government. You're no longer suing the federal government. You're no longer suing the Treasury. You're not suing the state. You are suing these people in their private capacity. And what this means is this: you're busting them for insurrection, rebellion, sedition. They have accepted pay under a false pretense. We now treat them like drug dealers. Everything that they own, everything that they have, now has to be sold. They have to be put out on the street. Now, they're sitting back and saying we can't criminally charge them. Yes, we can. Because it is in the written law that Congress says as a PAG under Title 42, 1988, we can charge them civilly and we can charge them criminally.
Isn't impersonating a public officer a crime?
Yes, it is.
Yeah.
But
So
see,
don't tell me there's no crimes here being committed
Yes.
on a daily basis.
So the thing of it is this: when we go back after them under the administrative side and we apply the 14th Amendment, we are now giving 2/3 back to the Treasury Department. Now it becomes profitable for the government to allow us to prosecute them because they're going to make money back off of us for prosecuting them. Where they get 2/3 and we get a 1/3 bounty. Have I got my 1/3 bounty yet? No, we haven't got it that far. Nobody has come this far to push it this far. We're doing it on 3 cases. I'm going to see how this thing works. Because we're going to go into the claims court. We're not only going to get damages for the people that were damaged, but we're going to go get the rest of it for what the fraud of the people, because they damaged a class of people. So we're going to go after everything they own and take it and then turn it over to 2/3 to the government. We get 1/3. They should either go to jail or they'll be put out on the street. Not my problem. Not your problem. Why? Because they don't have a problem doing it to you and I.
No, they don't.
So for you to have a moral conscience here, well, Rod, their moral conscience of sitting down and taking you out of your job, throwing you in jail, losing your job, losing your retirement, losing your income, destroying your family, I have no pity and I have no remorse because they have put themselves into this position that we need to go back and do accountability on these people. This is the whole function of this job. And ladies and gentlemen, Congress wrote it in the statutes for us to go do it. That's the beauty of this. Congress laid it out for us to go do it. That's our remedy.
Yeah, and people will say, "Well, you don't need permission to do it." Well, no, you don't. But when you have tons of neighbors around you who think you're crazy as it is because you're trying to tell the truth and they don't get it and they don't care, but when you try to substantiate and explain what you're doing in a way that those types of people would understand. They can understand its congressional intent. They can understand that Congress gave us this authority. And it's not seen as insurrection. It's not seen as being a domestic terrorist. It's not being seen as crazy. It's in black and white.
And see, this is what threw the U.S. Marshals. Because the fact that I was able to explain it, and then I showed them my congressional stamps. Now, I went that extra step to get those congressional stamps, and that has saved my butt more than once. Because they could have come back and say, well, you're doing this on your own. No, here's my paperwork. Here is my Senate and House Judiciary Committee seals. Here's my authority. Because me having congressional stamps, they cannot question it now. And this is where, with the training that we're doing here, nobody comes under my seal, under my approval for what we're doing. And we're not trying to make this, how do I want to say, self-centered. But these people out here are organized. And they all work together on railroading us. They got one way to railroad us. Okay? And this is what we're coming in. If we're going to go after these people, then I need to know that you can walk, talk. I need to know that you can walk into a court, bring a claim, go before a judge, and corner that judge. I need to know that you can turn around and bring a claim against a public official and get them to admit they don't work here.
Yeah, and you also want to make sure that they don't get themselves in trouble in any way, or do or say the wrong thing that might get them in some type of trouble. So if they're all trained the same way and they're all, have the same type of education, and work as a uniform group, I guess you would want to say, with the same process, that shows the system that you all know what you're doing. You're organized. You know what you're doing. You're working kind of like the military.
Well, we are. But see, what it comes back in and proves is this. If what I have been doing is wrong, on the federal level, on the state level, I would have been charged. The law enforcement is coming back in, the FBI, U.S. Marshals are coming back in, and they're looking, and even with the sheriff's department in my areas, they're coming back in and they're saying, oh crap, we can't touch this man. He can take us down. Okay, you have people like Anthony Williams that's out here doing the PAG stuff. He's sitting in jail because the Bar Association got him practicing law without a license. Well, you know what? The judge and the prosecutor could have done the same thing to me in D.C., except for one thing. I explained where my authority comes from Congress and why I can do what I'm doing from Congress. That's the same thing with the U.S. Marshals. I laid down the rules and regulations and how they're supposed to follow them. They can't very well bust me for using their own technique against them and laying it out and putting it in as evidence. That's the secret to this thing. You've got to be able to talk and be forceful with them as that they're trying to be with you. Make the point. Here's your rules. You violate your rules, I'll bring charges. And but then, like I did in Missouri, the judge committed the crime. I went down, filed the paperwork. I served them. Within minutes of a crime being committed, they were served. Now, U.S. Marshals didn't stop me. Okay? They did not stop me. They did not intercept me. They did not interfere. They did not block me. They stood off to the side and let me do my job. Try doing this any other place without their credentials, without being able to prove yourself. Ladies and gentlemen, I have a reputation with the U.S. Marshal Service from D.C. all the way across this country. They know who I am. They know what I do. They know my intentions are to do accountability on these people. I'm not in here threatening. We're doing accountability. And that's the difference. Understand that difference.